Okay, welcome back to Law and Crime Report. I'm your host, Bob Bianchi. We have a special treat for you right from the get-go of this show. I want to bring on immediately my good friend, Elura Nanos. She is, and I'm reading this from her Twitter account, so these are her words. A lawyer in life and on TV, Staten Island girl living in Jersey, columnist, law and crime, lover of music, by the way, may I add, a flutist. That's not in her Twitter. I happen to know that. She lost a meatloaf contest to me, I think, a couple of years ago, but your meatloaf was very good, nevertheless. And you're also a legal analyst. Laura, great to see you. Welcome to the show.
Thanks so much, Bob. It's wonderful to be here with you.
Yeah, it's been a long time from the early days at the Law and Crime Network when we used to be together and on other shows as well. Elura, you wrote a tantalizing piece, and you are really a great writer. I love reading your articles, and it's prosecutors seeking justice for George Floyd are wrong. The trial needs to be televised, all of it. And you go on to say that prosecutors are trying to stop that from happening, even though a court has said that they're going to televise the trial. And you have a very interesting, perspective here. So tell us, Elura, why do you think it's so important that prosecutors are making a mistake here by asking it not be televised, and why, in fact, it should be?
Well, look, I understand that prosecutors like to control the courtroom. I understand that. I was a prosecutor, you were a prosecutor. We get it, that you want to kind of do what you can to keep control over the courtroom. But in this case, that sparked major national interest. I mean, to put it mildly, this is a case that the public needs to see, and for so many reasons. The public needs to know what's going to happen to the people on trial. The public needs to see evidence to make its own judgments about what that evidence means to our society. And I think most of all, the people of the United States need to see justice in action. They need to see transparency from these prosecutors. Only that is going to have any meaning to bring us to any kind of national understanding in this case.
Laura, what was fascinating to me about your article is that the whole idea about having open courtrooms, especially in criminal trials, was to ensure, as a check and balance, that the public could be there. But like you say, this case is a global and an international case, and everybody can't get out there to look at the trial, and there wouldn't be enough room to accommodate it. But I want to go to another thing I think I kind of read in your article, if I was reading between the lines, or you may have came right out and said it, that there's nuances. And I've been arguing different defenses in this case. Not all of the conduct of these defendants is the same. And against, I guess, a majority of the opinions against me. But like you said, I've prosecuted a lot of murder cases in my day, and a lot of cases like this. The bottom line is not all defendants are going to be, in my mind, equally culpable here. And if there's a not guilty verdict or a verdict of something lesser, how important is it that the public gets to see what went on, to understand it, so that it could potentially avoid violence in the community?
I think that is right on, Bob. This is so important. It's very easy to just watch a brief video or listen to a news commentator and walk away from it saying, this is a terrible case of racial injustice, and I know everything about it, and I know exactly what I think should happen, and I know exactly what sentence should be imposed on these four people. But the truth is, things are not quite ever that easy. And that's not to take away anything from wrongdoing here, but there are different crimes being charged. There's different evidence that's going to be relevant for different defendants. And the best way for the public to really understand what an eventual verdict will mean is to follow along and understand what the jury was looking at to come to that verdict. Because without that understanding, all it's going to do is frustrate millions of people who are watching. The only real antidote to that frustration is information. And the only way we're going to get that is by full transparency and full broadcast of this trial.
Yeah, and the arguments raised by the defense as to why this should not occur, why it should not be televised. We've been televising trial. I was in the middle of a murder case, Elura, when I was a young pup as a prosecutor, and would literally get done with that trial and run downstairs to see the O.J. Simpson case, which was the first televised trial I ever saw. And that was decades ago. What possibly could these high-powered people supporting the government's position have no cameras in there? What are their arguments to justify this? And do you find them valid? Obviously you don't, but. What
No,
happened?
I don't. But look, I'll tell you, just because I don't find them valid, it doesn't mean that I don't find them having any merit at all. I mean, there is an argument advanced here that we need to protect witnesses for what may happen, everything from intimidation to public ridicule. And that's not, unconcerning. It's just that it doesn't outweigh the public need. And there are mechanisms in place to do things like protect witnesses. But I think that ultimately, what the request here to get rid of the cameras is about covering their butts from both the
Uh,
prosecutors and the defense attorneys.
Well, I want to talk to you about that because we've seen a lot of high profile cases. And to your point, as a prosecutor, I never had a problem if the media want to come in. Everything we've got is an open book. You can see it from beginning to end. But Elura, we have seen a disturbing trend. And I know people aren't going to like this, but it is a fact where people are jumping to conclusions and that there's a lot of political pressure placed upon these district attorneys, especially the ones that are elected officials. We've seen that from the Mike Nifong case and the Duke LaCrosse cases it's referred to, and in many other cases, Marilyn Mosby and those police officers. So could it be that, like you said, it's not so much second guessing, they're afraid that it's going to be exposed that they jumped to some draconian choices in this case that they otherwise would it was imprudent, but did it because of the court of public opinion pressure, which never works in the court of law.
I mean, look, I think that's one possibility, but I think there's also an equal possibility that these are good charges with a good prosecution and everything about it is totally above board. And the prosecutors just don't want to be under a microscope of public scrutiny. I don't think that looking to get rid of the cameras means that anyone feels particularly guilty about having done something wrong or done something for the wrong reasons. But I think that it is in many ways, unfortunately for the lawyers, kind of a no-win situation for them in terms of public opinion, because no matter what they do, people will criticize them. And if they
Right.
are elected, that's an even bigger concern.
Well, your article said, and I love the phraseology, this should be covered gavel to gavel because that's what we do here at the Law and Crime Network. And in fact, many times when we are covering those trials, we find out that the facts that are actually elicited were far different than what the media portrayed them to be. Elura, it was a great article. If you get a chance, go on the Law and Crime website so that you can read the entire thing. Switching gears, Elura, to another passionate subject that you are writing about. After the Supreme Court of the United States last week, I believe it was, ruled that the New York Governor Cuomo restrictions on religious institutions are thrown out, and that was a major decision, a 5-4 decision. Well, in Kentucky, we have a battle between the governor and the attorney general who are from two different parties. And the governor there has said, no, schools, religious schools, private schools cannot meet in session. And the AG filing against the governor wrote the following. In Kentucky, one can catch a matinee movie at the movie theater, tour a distillery, work out at the gym, bet at a gambling parlor, shop, go to work, cheer for the Wildcats or Cardinals. These are pandering there for the sports teams. And attend weddings, attend daycare or preschool, and college kids can attend classes, but all of Kentucky religious schools are shuttered. I love that word. Elura, what are your thoughts about this?
So my thoughts are that we really see what happens here when one Supreme Court decision causes just a wave of litigation, right? So first of all, it is sort of sensational for them to have claimed everything else is open, but the religious schools are closed. Because the reality is all the schools are closed, whether religious or not. Now, that's not to take away from some real inconsistency that preschools are open, but for example, kindergartens are closed. So there's certainly inconsistency there, but the inconsistency is more about which schools as opposed to religious versus non-religious. However, we saw in the wee hours of Thanksgiving morning, the Supreme Court hands down this 5-4 ruling that slams the New York COVID regulations, rules against them, and rules against Cuomo. So now we have, this case had already been pending, but now the big question is, what is the court is going to do with this? And what's really interesting is that this emergency petition in Kentucky came before Brett Kavanaugh. And that's just because, there's a justice assigned to each district. Well, another case, just moments before I went on air with you, Bob, another case in California that had been assigned to Justice Kagan for also something similar, also filed by a church, also about COVID regulations. In that case, there was an order handed down early today that said, send the case back down for a ruling consistent with that Thanksgiving Day New York ruling. So we're just seeing major, other shoe falling in so many ways on these COVID restriction cases.
Well, Elura, you have, just from the procedural history point of view, if you could just briefly get into that, the battle between the governor and the AG. And, again, this gets the whole idea. I presume in that state, they're elected. So you have an elected governor of one party and an elected attorney general from another. I can't emphasize enough, in New Jersey and many other states, you're appointed by the governor. So there's a little bit more consistency there, and there's not so much politicking, but there's obviously a battle now between the governor and the chief law enforcement officer of that state. Can you tell us the legal wrangling of what's happened? And lastly, is it possible that Kagan could remand the case for further determinations, but Kavanaugh can take that similar case and hear it?
Yeah, yes and yes and no. Okay, so let me get to the procedural history first here. I agree with you, Bob. I think it's outrageous that we end up in a situation where you have a governor of a state, handing down, orders, handing down executive orders for the purpose of protecting people in the state. And then you have the chief law enforcement person saying not only do they not want to enforce those orders, but they're going to actively litigate against them. Really, that's something that from a procedural standpoint doesn't look good and really shouldn't happen. But in Kentucky, that's exactly what happened. You have Bashir, who is a Democrat. You have the AG, who's a Republican, joining with the Christian schools to fight against these COVID restrictions, saying that they were overly broad. That is pending before Justice Kavanaugh. And, there's a couple of things that could happen. Kavanaugh could issue a ruling just on his own. Alternatively, it could go before the full Supreme Court at this phase, or as Kagan did, it could be remanded back down with an instruction that says rule consistently with what just happened in the New York case. So there are a number of outcomes here, but I think that based on what happened in the case in New York, there's little question that what ultimately will happen is that for most of these cases, you will see the governor's executive order fail, the religious institutions prevail.
Well, Elura, I just got to ask you this last point. It's on topic, but not so much. When you read what the AG wrote about going to gambling parlors and you can shop, and I myself have looked at this and said, well, you have to have a compelling state interest in my mind to be able to do something like shut down a religious institution. Are there other ways to accommodate it? Like what got me was one of those cases, I don't remember what state it was in, where they allowed attendance at all sorts of functions up to 50%, but not for, religious facilities that were given a different number. Now, it just does seem to me that when it deals with economics, they don't have a problem in allowing that to occur. But when it comes to religious institutions, it doesn't seem to me the same rules apply, respectfully. I just see this. There are ways to protect people in their worshiping. You may have to limit it. You may have to make sure that you're not having those massive rallies that have been going on. Yeah, but to shut it down completely, I don't know. I think there's inconsistencies.
Well, I think that, 2 points. On one hand, I certainly agree with you. There are definitely inconsistencies. And I think that is by nature of a pandemic. Nothing is ever going to be totally consistent. But I will disagree with you on one thing, and that is the relevance of what's happening in, for example, a shopping mall or in a store versus what's happening in a church. Because really, when you think about the logistics of what's happening in a religious service, it's much more like what would happen in, say, a theater or a concert hall, where people are sitting next to each other for prolonged periods of time, as opposed to a supermarket where people are passing by one another. There's also been significant evidence that things like singing and talking actually is more risky. So I would really want, if we're talking about consistency, which I love consistency, what I really want is looking at things that are really more of a one-to-one relationship. And I think that's closer to things like mass gatherings as opposed to things like gambling and shopping. But I agree. I think that the consistency is a problem. And I think that that's what we're seeing come out of the Supreme Court, really just not willing to tolerate that, right, especially right, taking a hands-off view on religion.
Well, Elura, you've proven one thing to me beyond a reasonable doubt, and that is you have never been around a craps table when somebody's on a hot roll and there's a lot of yelling and screaming going on and people in close proximity. But I get your point. I love having you on. Please, let's talk to the Law and Crime Network about a possible meatloaf contest when we're allowed to be back together again, because I want to give you a crack at the title. Elura Nanos, you're the best. I love having you on.
Thank you. See you soon.
Okay, we're gonna go to break. We'll be right back. All right, welcome back to the Law and Crime Report. I'm your host, Bob Bianchi, and because Elura is gone does not mean we don't have two great other guests that are going to be with us on for the rest of the show. Let me introduce to you first Jamie White, Esquire, out of Michigan, the owner of the White law firm, Mass Torts, like Flint, Michigan, and other major stuff. I was very impressed when I was reading your resume, including mass actions for victims of sexual assault, to criminal defense, appellate practice, personal injury. His firm does it all, and he's also a media and legal expert. Welcome to the show, Jamie.
Thanks for having me, Bob.
Absolutely, my pleasure. And Holly Davis out of Austin, Texas, former assistant district attorney with the Kirker Davis law firm, primarily handling family law, divorce, custody, and child support, also business litigation and estate planning. Welcome to the show, Holly.
Hi, Bob. Thanks for having me.
My pleasure. So listen, guys, we got this bribery for pardon scheme that's going on. I mean, like, what else can we pile on? It reminds me of that My Cousin Vinny. How much can we pile on to what is going on out there? But essentially, a federal judge unsealed some information with respect to an investigation that goes back to August of 2020, saying substantial political contributions were offered in exchange for a presidential pardon or reprieve of sentence. And essentially, Attorney General Barr, who, as most of you probably know right now, is in the hot seat with President Trump after he debunked any claims that there was a substantial voter fraud that would have affected election. And just before we came on air, there is a significant information that he may be on his way out. So we may yet have another fired Attorney General and another one coming in. Nevertheless, Attorney General Barr on this particular investigation tried to prevent the release of the information, keep it sealed, but the judge ruled that transparency would be mandatory. Holly, let me go to you first on this because I'm sorry, I apologize. We actually have a clip. Let's take a listen of it and I'll get to you guys on the other side.
As you said, this was a bombshell court order that was unsealed yesterday from an investigation that we know has been ongoing since at least August. The order basically showed that federal prosecutors had been looking into what they called a bribery for pardon scheme and also a secret lobbying scheme. Now, the secret lobbying scheme tried to ply senior White House officials, according to the court papers, and that essentially the government has been trying to get information about this, and they went to court to try to defeat attorney-client privilege. The judge allowed it. And that investigation, when she allowed it, Chief District Judge Beryl Howell basically gave a 90-day window and said, at the end of these 90 days, you have to tell me what we can release publicly. And so we're finding out about it now.
All right, so you said a few things that kind of caught my ear. You said it happened since August, but why are we finding out about just now? And do we know who unsealed these documents?
Well, the judge basically gave that 90-day window, and she told the government, at the end of these 90 days, let me know what I can release publicly. Now, interestingly, the Department of Justice tried not to release anything, and they recommended to keep it entirely under wraps. Judge Howell rejected that. And so essentially, by overruling them, she gave us a little bit of a public window of an investigation that has been long brewing.
Okay, so that's an investigative reporter, Adam Klasfeld, that was speaking with our very own Brian Buckmeyer on Law and Crime Daily, a great show that you guys should always watch, of course. So let me go to you, Holly, for a second. Let's talk about, I mean, I can understand as a former prosecutor that investigated cases, the Attorney General's reluctance to release information while an investigation is going on. But I find it even surprising that the Department of Justice is even pursuing an investigation like this, given how Attorney General Barr has very much supported the Trump agenda. But if true, these are some serious allegations, no?
Are we surprised, Bob? Are we surprised that we've got a bribery scheme that's been brewing by a convict since August that's seeking a pardon from the White House? I'm not surprised. What I am surprised about is the level of transparency that Judge Howell has allowed. And I think that's wonderful. I commend the checks and balances of the legal process to allow that. When I read the order from Judge Howell, most of it was redacted. In fact, all of the background was redacted. We don't know who sent what to who. But we also know that technically this attorney-client privilege argument that was being asserted did not prevail because the communications were forwarded to a non-attorney and not an agent of the attorney either. So that argument failed because it wasn't protected and kept simply between the attorney and the client. So I think it's really fascinating that we've got from the top a White House that has been following different rules to the different beat of its own drum. And I'm not surprised now that we've got people coming out of the woodwork looking to have pardons and favors from this White House, which doesn't necessarily follow all of the rules. So I'm very fascinated by this development, and I'm curious to know if we'll get to find out more about who these players are.
Yeah, Jamie, to that point, a lot was redacted in that information, and I'm told a number of names were redacted from that as well. Talk to us a little bit, Holly kind of touched on this a little bit, but the crime fraud exception to the attorney-client privilege as well here was asserted as one of the reasons why the judge allowed the government to intercept these communications.
Correct. So, Bob, as attorneys, we cannot participate in any sort of activities that are perpetuating crime. And if in fact you are involved in that in any way, shape, or form, you can't go back and rely on privilege to hide that impropriety. I do want to illuminate a little bit. I agree with Holly 100% that there's nothing shocking here based on what we've seen over the course of the last 4 years. I would suggest to you and your viewers that I don't think the names here are secret. I mean, they certainly have been redacted, but I think we know who these players are going to be. It's going to be Mr. Kushner, it's going to be Mr. Giuliani, and arguably other people at that highest level of the executive branch. The shocking nature of what's been alleged here is it really is mind-boggling. We have seen pardons passed out over the course of, every administration has done that, some more than others. We had the Mark Rich situation with President Clinton, but there we had a situation where Mr. Rich had been a historical donor. Here, the allegation is that they literally were paying for relief, or at least anticipated relief. And, Bob, the thing that I think is going to really shock the conscience of the courts going forward in this case is that we're dealing with people that haven't even been charged with a crime yet. We're dealing with an anticipation of a crime. So Mr. Trump and his associates are apparently looking to shed a broad blanket over any possible incriminations that he and his family may come into. And I think this is going to test the courts.
Jamie, you bring up something that's really important here. And that I believe this list is going to be longer than just the Jared Kushner and Giuliani, because they're talking about paid political contributions. And obviously the president's not going to require that of his friends and his family. So I think the list is going to be longer. But, to the point, Holly, we are now at a spot where, remember when when Obama left and they were chanting, lock her up with respect to Hillary Clinton, there could have been no better opportunity than for President Obama to pardon her just out of fear that they would follow through, because we know the Department of Justice has been weaponized to go after the foes of certain people and to shield those who otherwise, it's just my sense, who otherwise are friendly with the administration. And the Obama administration did not pardon Hillary Clinton. I don't know if that was ever in the cards or not, because I believe the Obama administration believed that she did nothing wrong. But are we now in a place where presidents are going to just say, you know what, I'm pardoning everyone. You can expect that at the end of this administration, you're all pardoned. And what that leads to, Holly, you tell me, is complete chaos, because everyone knows they can act with impunity and lawlessness at the highest level of the branches of government.
Impunity and lawlessness. Those are two excellent words to describe some of the issues that have arisen over the past 4 years. And so I think that we are in an unprecedented time, obviously. And I think that right now we have a president who has refused to accept the actual election process. And when you have that level of disregard for the rule of law, for rules in general, then we're dealing, you're right, with a completely different chaotic situation. I think we are to expect a slew of pardons. I think we are to expect a slew of pardons across a broad swath of people that were associated with Mr. Trump. And I think that's because there were, people were coming close to the line and to the edges. We saw this back in January of 2020 during the impeachment process. We had a president who was reaching out to the president of Ukraine to withhold aid so that he could pursue information on his Democratic rival. So everybody in this administration, from the very top down, has walked the line of legality. And this is not an opinion. These are the facts that we can read in the paper or we can read on Twitter. And so because of that, we are about to enter into the next 4 years, a phase of what do we do with the chaos that ensues from the fact that we are literally making up the rules as we go sometimes, as the administration does. And so
Holly,
it's not a judgment, it's just a fact.
Holly, excellent point. I have to end it there. I've got to switch topics, but it will really be interesting to see, will there be accountability, or will the Biden administration or the Attorney General that Biden, places there to say, let's just move on, and what message that send? Guys, let me ask you this question. The Supreme Court right now is weighing whether non-unanimous jury verdicts are constitutional. Jamie, what are your thoughts about this? Because this would be a major departure from our system.
This is terrifying, Bob. The idea that we're going to get away from the constitutional right to a jury a trial by jury. This idea that we're not going to have a unanimous verdict when it talks about taking away somebody's liberty, putting people in jail, and arguably in some states taking away their life. The idea that we're going to depart from this is very, very troubling. I know that the district court has spoken on this, and my understanding is that it's going to be sent up to the Supreme Court via Mr. Kavanaugh initially, and this ruling, in the event that this is allowed to stand, this should raise a red flag like that's never ever been flown. We allow non-unanimous verdicts for civil proceedings where people are talking about property or some sort of civil rights. But when you're talking about taking away somebody's liberty and somebody's life, to depart from this precedent is truly terrifying.
Okay, yeah, Jamie, listen, as a prosecutor, I welcome 12 jurors and proof beyond the reasonable doubt. I guess call me a traditionalist. Guys, we got to take a quick break. We got more on the other side. Please stay with us. We'll be right back. Welcome back to the Law&Crime Report. So we were in a discussion where the United States Supreme Court is going to be deciding whether or not non-unanimous jury verdicts are unconstitutional. Holly, I wanted to give you an opportunity because I really believe this subject needs a lot of discussion, a lot of public education. For those of us that watch on Law&Crime on Facebook, please, we'd love to see your commentary. But Holly, what are your thoughts? Do you share Jamie's concerns that this is a bad path to go down?
I do, and luckily the Supreme Court of the United States agrees with Jamie and I. And so really the case before the court is whether or not this non-unanimous jury verdict prohibition, which was issued a couple months ago by the Supreme Court, can be applied retroactively. So Oregon and Louisiana were the two states out of the entire country that had these, that permitted non-unanimous jury verdicts. And a couple of months ago, the Supreme Court ruled that the Sixth Amendment prohibits that practice moving forward in the future. And now the question is whether or not thousands of people in the criminal justice system in Oregon and Louisiana are going to get this rule applied retroactively. And I think that it absolutely should apply retroactively. Bob, you speak about educating the public about what's going on. And what's going on in the world right now and in our country is that we have a giant racial divide. These practices were implemented in Oregon and Louisiana to prevent Catholic, Jewish, immigrant, Black jurors from having their voice be counted when they were in the jury box. And so, and that is something that, these were developed in the 30s. These rules permitting non-unanimous jury verdicts. So if we're really truly trying to heal our nation and to heal and bridge the racial divide, as I believe we all want, or a majority of the country wants, the first place to do that is to prohibit these practices moving forward and fix the past. And there's only a few circumstances where the Supreme Court can actually apply this retroactively. And I think this is one. When we do this, Bob, we send a message to states, to DAs, to prosecutors, to voters, letting them know that even if you do find a workaround that results in a racist move that prevents our community from having a voice, then even if that practice is permitted for years, it will be made right at some point in the future. And if that is troubling and hard for the criminal justice system to redo all of these jury trials, that might prove as a consequence the next time we're trying to impose such a decision that really infringes on the Sixth Amendment right.
Yeah, Jamie, I'm going to give you the last word on this. What do you think about that racial angle that Holly brings up? And, I always used to say to my prosecutors when I trained them that do it right, do it clean. Even if you can, doesn't mean you should, so that this way it could withstand constitutional scrutiny when it goes through the appellate process. Because to Holly's point, there's nothing worse for a prosecutor than having to retry a case because it never gets better. What do you think, Jamie?
Yeah, so I agree with Holly. Her presentation was extraordinarily elegant in that regard. Look, it should be hard to convict someone of a crime. We should have to work really, really hard to take away somebody's freedom, remove them from their family, and hold them accountable for whatever the allegations might be. And any attempt to circumvent that and make that easier on the state is completely contradictory to what the founders anticipated. As far as race is concerned, look, we know. I tried criminal cases for 10 years, and in the community that I was from, it was a miracle if we could get a African American on a jury panel. It just was the nature of the beast. We're a 80% Caucasian community where I'm from in mid-Michigan. And, at the end of the day, if we had one African-American on the jury, it was a miracle. But it was important because the vast majority of the defendants were African-American. And I can tell you that, as we pool juries, as you guys know, we pool juries once a verdict comes back and we try to get a feel for where their head was. An African-American or, a diverse panel as it pertains to gender or religion, it makes a difference. If you have a homogeneous panel, the outcomes become much more predictable and oftentimes prejudicial. And so, again, this to me is just one of the most troubling things that I've seen over the course of the last several years. And I hope that the Supreme Court will address this and affirm an individual's right to a trial by jury in a unanimous fashion.
It's all about the jurors, the jurors, the jurors. Guys, excellent commentary. Thank you so much. Got to switch gears a little bit. A real tragedy out in California. An individual, Jerry Boylan, 67 years old, was a boat captain. Has just been indicted by the feds for the death of 34 people. It occurred on September 2nd, 2020 at approximately 3:30 a.m. They were just 20 yards offshore in 60-foot deep water. The rescue people could not even get there because the fire was so intense. Many of them died below deck. There were a few survivors. Now, we're going to listen to the National Transportation Safety Board that did an extensive investigation with regard to this and some of the conclusions that ultimately were used by the feds in order to secure this indictment.
We don't know if that detector went off, and we don't have any record of its operational status. A crew member did state in one of the interviews that he thought he heard a faint alarm sound while he was on the upper deck, but he couldn't pinpoint where that was coming from. It may have been that detector, but we don't know.
Well, my next question would be, I don't know if I read that same thing and said there might have heard a chirp, which would have been probably the smoke detector, but did the heat detector, what was its sound? Do we know? And do we know if the crew even knew what the sound of a heat detector going off is?
I don't believe so, because there was no policy or schedule for really testing and demonstrating its operation.
Okay, yeah, so that's a concern. If crew members don't know what the sound is, or passengers don't know what the sound of a smoke detector or a heat detector is, how are they going to know that there's an emergency? It's amazing that we have an unattended room that has battery chargers on it, a flat top griddle, 2 burners, refrigerators, and we have no regulations that require a smoke detector in there. Just amazing. We're asking the Coast Guard to revise the regulations to require all vessels with overnight accommodations to install smoke detectors in all accommodation spaces. I would hope that that the Coast Guard would take us up on this recommendation and make it a regulation. But I do know it takes time. So I would ask those other operators out there who have boats just like this, that a 2-pack of battery-powered smoke detectors costs $25 at the local hardware store. And I plead with you to go ahead and get these and install them before the regulation comes out in all your spaces, so we don't have a tragedy like this again.
Okay, that was from October 27th of this year. Now, the indictment indicates that Boylan caused these 34 persons to die, quote, by his misconduct, negligence, and inattention to his duties, which, as you heard, there were safety violations that were found, failing to have a night watchman, failing to conduct sufficient drills and training with respect to his crew, and failing to have basically the passengers properly vetted as well with regard to making sure that there's safety. Holly, let me go to a question that I have. It's a very serious indictment against this individual. He's facing a 10-year maximum. That's probably on each count it's a serious sentence here. There's a lot of people that died. But what about the civil ramifications? Do you expect the company is going to be sued for this?
Absolutely. I absolutely do. And I think that we've got an issue here where you see the worst case scenario actually does happen. A lot of times businesses and companies and organizations want to really make things efficient, and I'm not saying cut corners, but some of them do. And this is one of the examples. I think that this is going to be an example of a case. I think this is going to try to send a message. I think that it's obviously, we can see from the clip that you showed before this interview that we're trying to change the codes and the requirements within these structures, even though they're off of the coast. You're still in basically a tiny little space floating on the water. It's very dangerous. And so we have to implement these safety standards. They're here for a reason. And unfortunately, these 34 people that passed away are going to lead by example. This is an example of a company that, and a leader and a boat captain who is not following the rules. And the rules are there for a reason. When you're doing anything over water, you are 1 foot away from death at all times. So when you're on a boat, you have to do things differently. And as a business and a company that is operating a boat, you have to do things at a heightened level of safety, just like the airline industry.
Yeah, Jamie, listen, this is like right up the ballywick of your law firm that handles these massive kind of torts that occur due to the negligence or malfeasance of individuals. What are your thoughts about the company being sued? I agree with Holly, the company is being sued, but what will they have to prove in order to connect the company to the negligence of the captain?
Mm-hmm. So, Bob, the company is certainly going to be the primary target, but they're not the only ones. And Holly touched on this a little bit. I mean, I think that at the end of the day, there's going to be lawsuits associated with the products that were in the boat. So, Holly talked a little bit about, and it's been widely reported that batteries set off this fire. I think there's going to be a look at those individual companies and those individual batteries and the cameras associated with those batteries as to whether or not, whether or not there's been previous defects associated with these products. So the civil lawsuits are going to be massive. The company certainly is on the hook, but they are not the only ones. There are going to be several other defendants associated with this lawsuit.
Right, and Jamie, I want you to kind of also let us know about this doctrine that we call respondeat superior as it relates to a company. and what that means. Like some people may say, well, why is it fair that if the captain didn't do what he was doing, that the company should be liable? How do you as a lawyer connect the company through that doctrine?
Yeah, no, that's a very good question, Bob. So at the end of the day, we make money and we have responsibilities associated with making money. And in the event that you own a company, you own a boat, you own an airplane, whatever it is, if you employ people and in the course of their employment, you're making money or some other form of consideration, and in their stead, harm is caused, you are responsible. Respondeat superior means that you are responsible for the people that work for you and help you make money. That is part of the risk of being in business, and that is the reason that we have regulations to hold people accountable when they are not when they are not being accountable for the people underneath them.
Right, and Holly, with a thing like this, where fire is the worst thing you can have on a boat, and because of the risk associated with it, you would think that the company, and I bet this is going to be something that's going to be argued, had a responsibility not only to have policies and procedures in place, but to ensure that there was compliance with those policies and procedures. Do you agree with that proposition that the company is pretty much going to take it on the chin for this? And lastly, the question is going to be how much insurance they have, at least from the company's standpoint, because that is a factor that goes into a case, unfortunately, because the only thing the court can give in compensation is compensation to these folks. You can't bring their lives back.
Right. I mean, the company's going to have deep pockets, and that's going to be their insurance. And the number is what it is. It's whatever the policy was that the company had. But the bigger issue is that if I'm a person that was on that boat, and prior to passing away, I went onto the boat, I signed all those waivers, I went onto the boat thinking that I would get off the boat, then, obviously there is an obligation on the part of the company that took my money to make sure that as I sleep at night, that I'm being taken care of. I'm not going to die in a fire. That is a basic rule.
That is an excellent place to stop. You guys, again, great commentary. Appreciate it. Going to take a quick break. We'll be right back. So listen, let's go right to the guests with regard to the Magagua case. Guys, this resulted in a mistrial. There were 3 defendants that were accused of a hit-for-hire plot. And essentially, she went to trial with a co-defendant. That co-defendant was convicted. There was a hung jury with respect to her case, and prosecutors are going to retry her again. Defense was in court on a motion to have her released on bond, saying that we're not going to have a trial probably until July. The next hearing's not scheduled until March. A jury couldn't come to a conclusion that she was guilty, and the judge denied that bond. Of course, they bring in the COVID-19 because that is a problem and often cited in bond cases now. Holly, give us your brief review of the case, what you thought about what happened at trial, and did the defense make a good argument that she should be released on bond and was not a risk for flight?
First, I'll start with the summary of the case. So this started with, unfortunately, a custody matter. So this FSU law professor was shot down, potentially and allegedly in a murder for hire plot from the family of his ex-wife, and they were in the middle of a custody battle. So the person who is in jail, who was convicted by the jury, was the shooter. And the question now is whether or not the person that was coordinating, allegedly, this murder through phone calls and was in contact with the brother of the ex-wife of the victim, whether or not she is going to be in trouble and found guilty. And so I think that this is very, very similar. If our viewers were watching the Erica Stefanko murder trial last week and the 2 weeks before that, then we'll find that there is evidence that if presented properly to the jury, a person who is encouraging and coordinating the murder can also be as guilty as the shooter. So I think that this case should be tried. I definitely think it should be tried again. And I think that it makes sense that bond was denied, especially in light of these pandemic times.
Jamie, what are your thoughts about the bond hearing and whether the judge made the correct ruling?
I think the judge definitely made the correct ruling, Bob. We see these murder cases play out in all sorts of different scenarios, but when we have a premeditated act that involves the planning of killing someone, to me, it suggests that, this person is not safe to be in the community, because when it comes to bond, we don't only look at the risk of flight, we also look at the risk to the community. And
The
I
danger
really can't
to
think.
the community. I agree, Jamie. Listen, I'm sorry I had to cut you off, guys, because we're at the end of the show. I will be back next week. These guests were awesome. Please stay tuned here at the Law and Crime Network for our regularly scheduled program, and you have a great weekend. Be safe.